welcome to the session about what you as a scholar might need to know about permissions and licensing. So I'm Chris Helpy. I'm your Associate Dean of Libraries and Information Sciences, and I'm joined here by two of my colleagues and co-presenters. Jill?
Hi, everyone. I'm Jill Gregory. I'm the Associate Director of Scholarly Publishing and Visualization. My functional role is Medical Illustrator.
Hi, everyone. I'm Becca Neal. I'm the Digital Library Administrator working with library systems and resources.
Perfect. Thank you. So we'll talk first about what we hope you get out of today's session. But also we will remind you that just as you heard from our titles, none of us are lawyers. So copyright permissions, agreements, these are all things that have a lot of legal language and legal ramifications. So while we'll talk you through how we look at them and how you might choose to look at them, we are not giving you legal advice. Mount Sinai has plenty of attorneys who are available if you need actual legal expertise. The goals we do have for today are for us to have a conversation about use of other scholars' content, how to interpret the choices about licensing that control how you're able to reuse their materials, give appropriate attribution, which is pretty much always required, and to navigate the permissions process when it really isn't obvious how to do the kind of things you would like to do with other people's materials. So the agenda for today, I will get us started with some conversation about what it looks like from the author-creator side of this. And then I'll turn it over to Jill to talk about copyright basics. Then Becca will come back and talk about how we do permissions for some very narrowly focused kind of things using information that's publicly available to you. We'll dig in pretty deep to permissions for AI use, which is a really rapidly changing field. Look at a couple of the license agreements that Mount Sinai subscriptions have in place, especially as they relate to AI, and then wrap up with some resources and additional opportunities for learning. So, all of us at Mount Sinai are probably involved with scholarly activity and creation at some place in this. And definitely we're on the reuse part of this where we're using content that's created by other scholars. So we're going to start off today a little bit about the creator side and the idea that you have to be able to allow people to reuse your work at minimum for the reproducibility that's required by good science or good scholarly activity. But then you really probably actually want a lot more reuse than just that kind of checking and whatever your peer reviewers and other folks need to have access to. Because to really, for your work to have impact, other people need to pick up on it, they need to build on it, they need to reuse it, and then you start, that impact can kind of lead you to your next creation. So think about where you're sitting on this today, because as we go through our examples, you might see them differently depending on whether you're the creator or whether you're the person who's trying to actually use the materials that are created by other folks. But we're going to start with the author-creator role. So the first thing to think about really is, what do you want to be able to do with your work after you publish it? And so the thing that's important as you're trying to select a journal that you want to publish, and you want to publish in a journal that people are going to see your work, but you also want to be able to still do the things you need to do. So the example on the right is from the New England Journal of Medicine's website, where they're very transparent. They say, if you choose to publish your paper with us, and they happen to be the benefit of having both high impact and high prestige, and have a very clear author permissions information, you can do a lot of different things. You can share the copies with your colleagues. You can include it in your courses. If you decide to write a book or other materials, you're able to use it there. They have a lot of different things you're able to do. And our colleague, Mia Bolton, who's here in this meeting, has worked on developing an online tool that can also guide you through questions you can ask yourself. It's called the Pre-Publication Agreement Flowchart. And Becca will drop a link to that in the chat. That's a work in progress, because as we have conversations with authors, we always kind of evolve what those questions are. But some of the ones we'll talk about today are on that flow chart. So if we go to the next slide, I want to contrast a little bit what we just saw with the New England Journal of Medicine site, where up front they kind of say, here are all the things you can do. Those agreements and those lists of what you can do change over time. So the first takeaway for today is that when you're submitting a publication, you always want to really closely read and save your author agreements, because what you see online today or what you see when you go into the author submission system today isn't going to be what you signed, 6 months ago, a year ago. And so if someone asks you, hey, can you give me permission to do this? You really need to be able to go back and look at what agreement you signed. But the number one most important thing is to understand what materials are covered. So this is an example from the journal Academic Medicine, which is a publication of the Association of American Medical Colleges, AAMC. It's a great journal. I think a lot of us read it and use it and happy to publish in it. But you want to be very close, take a very close look at their copyright transfer agreement. So on the left, what you see under that little layer F is that if you submit an article to them that has appendices and other materials as supplemental files, they actually will be getting the copyright to all of it. So if you designed a survey that you're hoping to use in other research, or you're hoping that other people will use your survey and their research to, again, kind of enhance that reproducibility, enhance that impact, once you publish your survey as an appendix to an article that you copyright transfer away in its entirety, you aren't able to give people permission to use that survey anymore. So if, for example, if you wanted to publish an article with a survey in this journal, you'd be much better off placing your survey in some other kind of repository, whether it's something like Open Science Framework or even on your personal website, anything like that, where you could then point to it in the article, but not have it be part of the article that's covered by the copyright agreement. Similarly, if you had like an educational video that you were writing an evaluation of the educational video and the video was in the supplemental materials, you would no longer have copyright ownership of the video if it was a supplemental material to the article according to this agreement. If you look at the copyright transfer on the right, the only one of those many rights that we gave you, we talked about on the New England Journal of Medicine slide, the only one that the AAMC grants you upfront is this one to republish it in a book if you're publishing a book. All those other things are kind of not clearly laid out here. Okay, so going to the next slide, publishers do need some rights. So I'm not saying this to say that you as an author should want to retain all of your rights. And I just want to share this example from PubMed because I think most of us use PubMed every day, so it's something that's very familiar to us. The abstracts in regular PubMed, when you do a literature search in PubMed, all of those abstracts are copyright protected content. The abstract was part of the article that the author submitted, and you saw they just transferred the copyright for that abstract and that article to the publisher. Part of the reason that this is important for the scholarly ecosystem is because if the National Library of Medicine wants to include thousands and thousands and thousands of abstracts in their database, they can't be going to every single author to get permission to use every abstract. They need to be able to go in a larger thing. So by you giving the publisher a right to the right of distribution or the right to assign rights of distribution, NLM can work with the publishers to have access to the abstracts, or in some cases the full text, depending on what kind of agreement they sign, in exchange for the visibility, right? And so what you're seeing now with PubMed Central, which is the open access article component of PubMed's ecosystem, is that many publishers who are perfectly happy to have full text articles in PubMed Central and get them read by individual humans, for citation and impact and visibility, are not as happy with the idea that now machine readable AI, everything can just use the full text of their articles for everything else. So you see on the right, this screenshot from the PubMed Central open access subset, where they say really clearly, just because it's open access and in PubMed Central doesn't mean that you can use it for text mining and other reuse. And they actually have a little subgroup of terms of use there that some of them are fine. If it's not commercial, some of them are okay in other situations. So you really have to read the fine print in all of these cases. But the takeaway here is that publishers really do need some rights of distribution to make these third-party things like literature databases work for our community of scholars. Next slide. So the last thing in this author section is simply that if you wanted to retain a right that isn't already listed in your author copyright transfer agreement or author agreement, there are tools like this Spark Author Addendum to Publication Agreement where they've already written up the language for you for potential rights that you want to retain, and you can offer this language to your publisher to say, yes, I'll happily sign your agreement, but with this addendum, which means that I can retain, certain rights, or this section 6 down here that Mount Sinai could retain certain rights, that your employer could do certain things with it. So these are just examples. So that was our kind of flow for the author side of it. And now I'll turn it over to Jill to fill in some of those copyright basics that we flew right over.
Thanks, Chris. Yeah, so let's just dive right in. So as we said before, not lawyers, but we're going to give you a general overview. Talk to a lawyer if you have an actual question. So copyright is a legal protection granted to creators of original work. It protects the expression of an idea, not the idea itself. So you can copyright a drawing of a heart, but not the idea that a heart has 4 chambers. One of the nice things about American law is that copyright is granted upon creation. So if I draw a line, I own copyright to that. I don't have to register it with the government. You can register copyright. That does give you additional legal protections, but the creator is by default given copyright of their work. Or the creator's employer, which I'll get into a second. If you're working for a company, sometimes your company owns the rights to your work. An important addition, oh, sorry, I skipped over a data point. Data itself is not copyrightable. So like if you have just like a table of numbers, that's not copyrightable. But if you take that data and you create like a special database with it, or you make a figure from it, then you can copyright that. And the Copyright Office says that works are original when they're independently created by a human author. This is new text that is in place because of AI. So the Copyright Office does not recognize things made by AI as being copyrightable. There are currently a few different trials going through the courts right now for people who are saying, no, like it took me 500 prompts to create this thing in AI. So therefore, like it was created by a human and I should be able to copyright it. And thus far, the courts have not agreed with that. But this is obviously, as Chris said, like an evolving landscape. So we're going to kind of see how things go. But for the moment, if the image or the article or the text was created by AI, you cannot copyright it. I wanted to share a link to this page. I find it quite helpful. I also put a QR code for it here if you want to take a picture of it with your phone. The copyright legislation is a 500-page PDF. No one's going to read that. But they have a nice kind of 1-page summary that explains all the basic tenets of copyright. And this is well worth taking 5-10 minutes to read it, especially if you're not that familiar with copyright. So I want to recommend this as a really useful resource. I'll leave it for one more second. So how long does copyright last? In the US, anything made after January 1st, 1978 is typically the life of the creator plus 70 years. In Europe and other places, they use the Berne Convention, which says a minimum of 50 years after life. After that time, the work could be in the public domain. But the takeaway here is that, generally speaking, probably anything that you're going to want to use or reuse was probably made after 1978. And even if it wasn't, the author is probably either alive still or hasn't been dead for 70 years. So you're probably going to be needing to check the copyright of everything that you are wanting to reuse. And I show this example of Gray's Anatomy to show it isn't always like black and white. So Gray's Anatomy has been in publication for over 100 years. But the most recent edition that's not copyrighted is a 1924 edition. And I can see that here because in the website it says here it's public domain. More recent copies of Gray's, even if they use some of the original artwork from the 24 or the earlier editions, they are still copyrighted. So it isn't a matter of just saying like, when was this made? Okay, I know what to do. You need to look at that copyright page in the book or check online to see if it's in the public domain or not. So I mentioned before about companies owning copyright. So while I said that, if I take a piece of paper and make a mark on it, I own the copyright. That's true on the weekends when I'm not working at Mount Sinai. 9 to 5, if I'm creating something for work, the second I go like this, Mount Sinai owns it because I have made a deal with Mount Sinai, like I will create art for you, you will pay me and give me health insurance. So like that's the exchange we have here. So it's called work for hire. So like you have hired me now and everything that I make for you, you own. So whenever I create anything for publication, you can see here how I sign it. I sign my name, but it's my Mount Sinai. I do not own it. Uh, if you were to be an independent contractor, you can also sign a work for hire contract with a client. So you can sign a contract that says, I'm going to keep the copyright, you can use it, or you can give a contract that's usually for more money that says, I'll create this and I'm going to hand the copyright over to you. You can do whatever you want with it. Another aspect of copyright that Chris actually touched on already a little bit is Creative Commons. So the idea behind Creative Commons, it's a more flexible rights permission situation. So if something is a license under Creative Commons, the author is basically saying, here, I'm going to tell you up front how you can use this image or this piece of text. You don't have to come to me, the author, and ask me for permission. I am telling you ahead of time, this is what I'm going to let you do. So there are 6 types of licenses ranging from the very open, CC BY, which is basically saying the by is the attribution. So if you want to use that piece, all you have to do is say, Jill Gregory made this illustration and I'm going to use it in my manuscript or whatever. But you can change it, you can use it to sell things, you can do whatever you want with it, as long as you say like this was made by Jill Gregory. The most restrictive is this one, CC BY attribution, NC non-commercial, ND non-derivative. So what that means is that you have to attribute to the author, you cannot use it to sell anything, and you cannot change it at all. These all still fall under copyright law and you have to comply with the stated terms. Then it says non-derivative means don't make any changes to it. And even if no legal infringement occurs, you can still be considered plagiarism if you don't credit the original creator. Tons more information about Creative Commons licensing can be found on their website. A lot of times we hear about fair use in the education or academic setting because people think, well, I can use something as long as it's for educational purposes, it's fair use, I don't have to get permission. So what fair use or fair dealing in the UK says, allowing limited use of a work without permission for certain purposes. There's a great PDF that Columbia put out that you can use as kind of like a checklist to decide if you are falling under fair use or not. There's 4 main buckets of questions to ask yourself around fair use. First is purpose. Are you changing the work? Are you using it as a reference, but you're doing your own writing or your own drawing to make your own unique thing? How are you using it? Are you using it for education in a lecture? Are you critiquing it as like an art critic? Those are all going to be okay. But if you're using it to sell something, not fair use. Is the nature creative or fact-based? If it's more fact-based, generally it's okay for fair use. If it's more creative, that's not as fair use eligible. How much of it do you want to use? Do you want to use a paragraph of text? Do you want to use the entire article? That's going to make a difference. And then what effect would it have on the market? Would your reuse of this item, and would that make the original item less valuable? Are you taking away market share by making this derivative or reusing this image in this way? Then it would not be fair use. And always negotiated license terms take precedence over any fair use considerations.
So I think we'll just add in here for one
Yeah.
second to say that
Yeah,
it
go ahead.
isn't the answer to any one of those questions. It's how those 4 pieces all fit together.
Thanks, Chris. I appreciate that. Yeah. Okay, so copyright infringement. In most case laws, best-known settlements are in the fields of art and technology and entertainment. So the Shepard Fairey case with the Obama Hope poster is an example of a copyright infringement case. But even in the most well-known cases, the terms are murky. So this is a quote from a law back from a case back from the 1800s, talking about like what are we looking at here when talking about copyright infringement? And it's like, is it adding something new? Is it transforming it? Is it making a different character? But the take-home message from this sort of word salad here is that there is no bright line. There's no machine you can put a piece of text or an image into and it will spit out and tell you, yes, this has been infringed or no, this is not infringed. It's really on a case-by-case basis. And ultimately, if it gets to the point of a trial, it would be up to the judge's discretion whether or not you violated copyright. So that's why you always want to err on the side of citing, of getting permission, of changing things as much as possible while still maintaining the message you want to get across, because you want to make sure that you are not infringing on anybody else's copyright. So here are some examples of clearly insufficient transformation. This is an article that I co-authored. This is my illustration from there. I've got the citation down here. This is a brain that I drew. Simply making it black and white, flipping it, sticking it inside of something else, tracing it and redrawing it, or cropping it. These are all considered insufficient transformations. So what you want to do is take this brain that if you were needed to draw a brain, you take my brain, you take another brain, it takes like 3 or 4 different brain illustrations and you combine them and you make your own original piece. So, but say you do want to use this image and you aren't an illustrator and you can't draw one yourself, what would you do? So, when adapting illustrations or written materials, so if the new work you create is substantively different, you may not even need permission, but it's still important to attribute your sources. You want to acknowledge your source of any adapted or referenced content and always obtain written permission if required. When you're straight up reusing illustrations, you definitely have to cite the original publication in your reference. You want to look at the terms and conditions of the journal or where it was published, and Chris is going to get more into that in a little bit. For subscription content, if Mount Sinai is a subscriber, you can talk to the library and find out more information about reuse. And again, always obtaining written permission if required. So err on the side of caution. When you're not sure, seek permission and credit the original. So as I mentioned before, when I create anything for Mount Sinai owns it. And as an institution, we have decided to try to retain our copyright whenever possible so that we can reuse our illustrations and for different publications, different authors, etc. So that's why whenever I sign my work, I have that copyright after my name. And I work with the publishers of articles to ensure that the copyright stays with Mount Sinai. So if it's a case like that where you look at an article and you see in the caption of the figure it says copyright Mount Sinai or copyright Harvard or whatever, you find the original author, and this person said, you know, I'm writing on behalf of this person who works at UCSF. They want to use an illustration that I made for a book chapter. Can I have permission? And they say how they're going to credit me. So whenever these kind of requests come across my desk, I always go to the original author I work with to say like, hey, would you be okay if this new person reuses the illustration I made for you? Assuming they say yes, then I will say, okay, I will create a form for you to use to be able to reuse this image. So here's an example of a form. This is a standard form that Mount Sinai uses. We've gotten it vetted by the legal department that says you may use this illustration in this publication on the cover or in the body of the journal, and you can have it on like a marketing website, but you cannot reuse it anywhere else. You cannot make derivatives from it. I'm going to turn over to Becca.
Hi, everybody. So now we're going to talk about some of the more traditional uses and navigating, you know, finding permissions for reuse of content in public-facing resources. So the first thing we want to talk about is how do you find those license terms and conditions for what you want to reuse? So think about if you're trying to reuse, say, a survey instrument or a figure that's in an article, something like that. You want to look at the most granular level first. So look at that illustration, look at that figure that is in the article. Is there any sort of expressed licensing verbiage attached to that figure? For example, is there any Creative Commons verbiage associated with that image as Jill described earlier? If not, you can kind of zoom out at the article level or even the journal level and take a look at just the publisher's broader license terms. Publishers are usually pretty good about making those findable on their site. Sometimes they show up at links at the bottom of the page or in general license and copyright links in menus. And yes, if you cannot find these terms of use for publicly available content, then you would naturally go by applying copyright fair use. However, if you're looking at subscription content, library subscription content, you can always reach out to the Levy Library and we'd be more than happy to help you navigate our agreements. So to just kind of walk through a scenario here, let's say we're trying to use this or reuse this figure from a Springer Nature article in one of our publications. If we look at the figure, there's no explicit information on this figure saying, there's a particular license to use just this part, just this figure. So if we zoom out a little bit, on the next slide, yes, we kind of zoom out to the article level. And Springer's really great about this, noting that there are rights and permissions associated with different articles. Especially, as we see here, this article is a Creative Commons licensed article. You will note that it is very narrowly licensed. So if you're going to use any part of this, including the image, which is explicitly stated here, yes, you have to attribute the article itself. You cannot use it in commercial ventures. You can't make money off of it. You have to release this image under the same level of Creative Commons license. And if we move on to the next slide, I think I've already gone a little ahead of myself here where we go over the overview of that information, so you didn't have to read that whole paragraph. Yes, so and again, kind of pointing back to the no derivative aspect of this. This is such a narrow license that you're not even legally allowed to make adaptations to it. And of course, you must cite the article. But what if your use doesn't fit this requirement? There's still a way to use it, potentially. So a lot of publishers, especially a lot of the larger publishers, kind of outsource permissions navigations to the Copyright Clearance Center, which I will refer to as the CCC from here on out because I can't say it more than one time without screwing it up. So you'll often find a link to, how do I get permission to this, or reprints and permissions in an article somewhere that pops you out to this CCC rights link platform. This is a good platform if you're linked out there. It's not like a spam platform. So what this does is it helps you walk through your use scenario to figure out if you can use this resource under whatever it's licensed, so under that Creative Commons license, or if perchance your use doesn't fit those requirements, maybe you're going to have to pay a little money, or Springer's going to give you other stipulations regarding the use. So if you'll take a look at the right side of the screen, there's kind of a laundry list of different case scenarios. And if you select one of those, we'll see on the next slide that there are even more granular little notes you have to kind of work through. So are you going to put it on a website? Is there a lot of distribution? Do you need a high-res image? All of this stuff. And so as you make all of these different changes to how you're going to use a resource, sometimes you'll note that a price populates, and it is sometimes not a pretty price. And so just to note here too, CCC is also really good about outlining, again, those Creative Commons licenses, and you'll see a lot of overlap with fair use in the write-ups that CCC gives you. So moving right along, we're going to transition to a different sort of permissions case that often isn't really explicitly covered on publisher pages, and that is the use of copyrighted material in AI environments, such as the use of copyrighted materials in custom GPTs. If we glance at this list on the right side of the page again, you'll see here that there is no mention of using an article, of using this resource in any sort of AI capacity. And that is often because publishers want to negotiate these uses kind of in a one-off scenario. And we'll talk about that in a little bit. So I am going to talk a little bit about GPTs here. I'm not going to go into too much detail because we don't have time for that. But if you are interested in learning more about the kind of finer points of AI and its use in the various publishing schemes or in education, please do check out the library's recorded sessions. We have a lot of options available. So yes, just in brief, one of the burgeoning kind of emergent uses of copyrighted materials in AI is their use in custom GPT creation. So custom GPTs, in a nutshell, are generative pre-trained transformers, but they're individualized versions of ChatGPT that serve a very specific purpose. They are trained by extensive prompt engineering and often by uploading documents as a knowledge base that GPT refers to. So functionally speaking, you have the GPT, which is the chat interface, and it just kind of generates language based off of math. And then you have this other element called resource augmented generation, and that is that information retrieval piece that kind of pops out to the documents that you have uploaded and then uses the GPT to present answers back to you. So now I'm going to hand over things to Chris to talk about the nitty-gritty of AI use, particularly for copyrighted materials.
Thank you. So yeah, so I mean, we're going to talk about that. We're going to use the scenario that Becca just presented as part of our kind of problem that we're using as we look at some of the terms and agreement items around AI use. So I want to just say that actually a lot of our publishers have had relevant policies for a long time. They're just usually called text and data mining policies that are relevant for machine learning. So before generative AI became so popular, there was actually a lot of artificial intelligence and machine learning activity going on, and it was usually being covered under text and data mining. So if you don't find something that says AI use, do look for like text and data mining use. What you see now, though, is many publishers are going ahead and just getting ahead of it by making a very blanket statement about all AI and not kind of distinguishing that at all. And then you have another set of publishers that are more like very, very specific about what you can do and cannot do. But at a high level, the answer is almost always going to be not without permission right now in the AI world. I do think that that's going to change and evolve as people realize they don't want to one-off negotiate all of the AI-related requests. But the other thing I'll say related to the custom GPT, and we'll come back to this, is that if what you're talking about is taking single articles or small numbers of articles that you've downloaded and processing them for your own learning by using a GPT tool, as long as the GPT tool is one that it's your account and your account is set up that it doesn't allow any data that's used in it to train external models, you're probably going to be able to do some of those AI uses without getting explicit permission. It really falls along if you can keep the content intact and giving attribution, meaning does the thing you're doing know that that's where it came from? Can it still give credit, which is kind of the most important thing carrying through all of this? So we're going to look at some examples, and hopefully this will help. So I'm going to start with one that is the most restrictive. So this is UpToDate, a resource that gets used on the clinical side all the time. And people ask us all the time, can we use UpToDate in large language models? And the answer is 100% no. And to make it simple, on the UpToDate search screen, they just put the text right there. And we've made the text on the bottom of the slide very large. And what I'm looking at here specifically is the third sentence, which says prohibits the inputting or processing of UpToDate content by or into any automated software or tools. That is by far the most specific, like literally don't paste our content into anything that is not our product. Straight up, fair enough. You can't do anything unless you go to them and have a specific situation. And yeah, please do ask questions in the chat. I think Jill and Becca can help address some of the ones that are there. So we'll go to the next slide. Right. So then we want to look at examples where you have some possibilities. So this is the New England Journal of Medicine's copyright ownership and permitted use. And they have both a section that kind of says what you can't do, right? So in general, you can't scrape, grab, transmit, post, translate, create derivative work from, or do anything with any of their content, including with AI tools, but this would be with anything. They're like, no, you can't stick a computer on our content without our permission. But then they just specifically added this all bold section, right? that's specific to AI, right? You cannot use New England Journal of Medicine content to train AI models or train machine learning without express permission. And why is this? Well, in part, this is because they are actually making contracts with all of the people who want to do this at scale. And it's another way to monetize their publications. So they don't want you to be doing it while they're also trying to engage with, I think they, for example, just recently signed an agreement with Open Evidence to let their content be used to train Open Evidence's question and answer model. So, you're competing financial priorities here. But this is where I think definitions matter, right? So is a custom GPT that you're locally doing, to help you make sense of their articles a model? A custom GPT is using a model from ChatGPT, but when you are training your GPT, are you to help you with your task by giving it prompting instructions? Are you actually training an AI model? So, you kind of have this like play there, right? And then they specifically say you can use the content for personal non-commercial use, provided you keep the copyright and notices intact. So in that case, you do have to have a training strategy that keeps the copyright and proprietary material together, right? And so you would have to train your GPT to say, don't give me a selection from that resource augmented generation unless you also give me the citation, the attribution that goes with it. So you're always keeping those two together. Of course, if you want to do something larger, you see here they have this AI and LLM initiatives where you can contact them and you'll get information about the fees you can pay to get the permission to do what you potentially want to do for larger scale activities. Okay. So finding terms and conditions, right? This is where I think that publishers are realizing that people aren't going to go out and read the full terms and conditions like we are today. So they try to, at the bottom of this, you can see where the big arrow, they've said, look, we reserve all rights, including those for text data mining, AI training, so in case you don't read the fine print, here you go. We're reserving all the rights. But then they go on to say for all open access content, the relevant licensing terms apply. And so this goes back to the Creative Commons. This site, Elsevier has lots of articles where people have paid a fee to make their content open access, and therefore those have different licensing terms than the overall Elsevier licensing terms, which we have on the next page. If you go ahead, Jill. Right, so this is the overall terms that if you don't have something attached to your specific article, like Becca was saying, then you can kind of broaden out to the journal. If the journal doesn't have something specific, then you broaden out to the publisher. And here we have the same thing. You can do it for personal, non-commercial, scholarly use if you keep everything intact, but you can't copy, display, distribute, create other derivative works, including using AI tools. So this might be one of those situations where you'd be clearly like, I might be able to personally have my custom GPT, answer questions about that article with me, but I can't, if you consider that custom GPT a derivative work in any way, I can't share it with other people. I can't, I can't do this. So you're making judgment calls about what's actually possible to do. If we go to the next slide. Right, so there is no one right answer to scenario 2 permissions for this, right? So if there's third-party terms of use that say clearly you can or can't, you should always adhere. You always have to attribute the right source to the right content. So how large language models are known to kind of not match up the right citation with the right content, you have to make that work. And that's why the RAG model, the resource augmented generation, is one of the only ones where I think you can kind of confidently do a good job with that. But if you are training it on any kind of copyright materials, and again, I'm not talking about big AI model training, I'm talking about just custom GPT local training, you shouldn't be sharing that with anyone who already doesn't have legitimate licensed access to the content. So here at iCIMS, you might be able to share that custom GPT with the people in your lab who should also have access to the same subscriptions, but you shouldn't be sharing it with anyone who's outside of Mount Sinai. And even then, like I said, depending on the agreement, with the depending on what the publisher says, some of the publishers are more open to this than others. So with the AI world, I think you really want to be reading carefully and kind of documenting and being conservative. So the example of being conservative is more that you could train your GPT on open access papers that are CC BY, which is the most free form license. Like PLOS Medicine would have those, and then you could share those more broadly with colleagues. So we have only a couple minutes left, so I want to move through some of the bigger licensing agreements. So as I said, I'm just going to share two examples. This is the AI text and data mining part of our contract agreement with the British Medical Journal, right? So it says you can't do any text or data mining or web scraping or using any automated analytical techniques on the site, right? But then you can do the things that are in their text and data mining policy. So they do have a separate policy that has like more of the details. But the big kind of scraping and data mining things you're absolutely not allowed to do. So no large scale content work unless it's a separate permit. Go ahead. But then you have other groups who are trying to lay out ahead of time for you. There are some things that you can do. We understand you as researchers want to do these things. So this is an example from Taylor and Francis's data mining policy, which we have signed off on, right? So if you go to them in advance and say, I want to do this project, you will get approved if it's non-commercial use and it fits these criteria about the amounts of how much information you're using, et cetera. So they're trying to make these things straightforward. Like if you set up your project these 5 ways, we'll say yes, and you can get on with your science, which is lovely. Because if you look at the next slide, negotiating these specific agreements actually takes a lot of time, and it might take money depending on what you want to do. You have to know ahead of time exactly what you want to do and how much content you want to use. I can't give you the details on this, but we did negotiate one for somebody's project recently, and the difference between 20 cases and 40 cases and 50 cases mattered. Where exactly are you going to store it? Which AI models are you going to use with it? Who is going to have access to this? When will you delete it once your project's done? How will you cite that you had this agreement with us? All of that had to be gone through in like a lot of details. And so you have to document everything because the people you start talking to are usually not the people you're talking to at the end of the negotiation. And in that case, definitely you also want to loop in the Mount Sinai license holder, in this case, the library, as early as possible, because we were able to kind of help make that all go a little bit better. But honestly, this is such an evolving world that I think these things will all be true. Still, these are like the generalizable moments, but the specifics of how long and how much and all of that, I think, is going to evolve. So to wrap up, we have some takeaways for you. Really, copyright is a legal protection, and most of the things you're going to want to do have protections. You can contact the rights holder if it looks like the rights holder still has copyright, but really, remember the license terms are most important here. And so anytime you are capturing license terms, using them to make your judgment calls, signing your own author agreements, gaining permissions to use a work, all of those things are things you want to kind of save or document for yourself in your lab notebook or other processes. And then if you have a choice between using open source versus subscription license materials, especially if you're doing AI work, please plan to use open source. You're going to need attribution for both, but your work and your life will just be a lot easier if you have open source where you've documented the terms of the agreements. Jill and Becca, do you have anything you want to add to the takeaways before we wrap up with the resource slide?
No,
I
Chris,
think
you did a good job.
Okay.
Yeah.
All right. So on the resources, we remind you that the scholarly, let me go again. Remember that the Scholarly Publishing and Visualization Hub is kind of the library's home base for all of these things to support you as authors and scholars and as reusers of other people's scholarly activities. So check out the hub if you have not already. And then we also have the AI resources from the Libby Library, which is a place where we kind of have all of the information about supports for our AI resources and trainings that were mentioned earlier. So at this point, I think that's what we have for you, but I just want to say thank you all for being here today.